Committee is ready to resume. It's my understanding that the gentlelady from Illinois has an amendment to be offered.
Yes. Thank you, Mr. Chairman. I do have an amendment at the desk.
Clerk will report the title.
An amendment offered by Ms. Schakowsky of Illinois.
Amendment will be considered as read, and the gentlelady is recognized for 5 minutes in support of her amendment.
Yes. My colleagues, I wanted to talk about one particular aspect of this bill that I hope that we can work together to fix. This deals with nursing homes that are also covered by the cap on liability. It would exempt lawsuits against nursing homes from the $250,000 cap on non-economic damages. And I hope you'll consider what I have to say. You know that making decisions to put parents, grandparents, or loved ones in a nursing home can be one of the most difficult decisions any of us will ever make, but it can be made easier by having confidence that we're putting them in good hands. Having worked on nursing home issues for decades now, I want to note at the outset that that most of them are excellent institutions with dedicated and hard-working staff. But unfortunately, you also know that there are a number of bad actors, and we have all heard some appalling stories of abuse, neglect, mistreatment at the hands of nursing home employees. This bill will deny some of the most vulnerable people in our country, the very elderly and persons with severe disabilities, the ability to hold nursing home providers accountable for pain, suffering, and death that result from poor care and abuse. Because they have no earned income, the only remedy for nursing home residents is non-economic damages that compensate victims for their pain and suffering or that are awarded by juries to penalize providers for egregious treatment. Can you put a cap on what Mary Stewart, a 72-year-old nursing home resident in Palm Beach, Florida, endured? After an 18-day stay in a nursing home, she had to have her left foot amputated because it became infected with maggots. Instead of changing her bandages and cleaning her wound regularly, nursing home employees merely wrapped more bandages around it until it was too late. And what about John Donahue from Massachusetts? The 93-year-old lost an eye when an aide's negligence caused a mechanical lift to puncture his face. The nursing home waited 15 hours to transport him to the hospital, where doctors were forced to remove his eye. He contracted an infection and died 6 weeks later. When his wife of 63 years could no longer care for him at home, William Kurth, an 84-year-old World War II veteran, was admitted into a nursing home. After undergoing hip surgery, Mr. Kurth was virtually immobile and at high risk of pressure ulcers. Despite this knowledge, the nursing home did not update or change Mr. Kurth's care plan. Consequently, Mr. Kurth suffered from untreated pressure ulcers, dehydration, and malnutrition, all factors that contributed to his death. There's also 78-year-old Margaret Hutchison, who was admitted to a nursing home for short-term rehabilitation after fracturing her hip and wrist at home. While at the nursing home, she suffered from severe pressure sores, malnourishment, dehydration, and later died. And clearly, these stories underscore that additional protections are needed for this vulnerable population. No one should have to endure the pain and suffering that these victims and their families endured at the hands of negligence. And these are not frivolous claims, and this is certainly not the treatment that a family agrees to when they place their loved one in a nursing home. And they are not unique circumstances either. You have all heard these kinds of stories. Limiting civil actions against nursing homes only protects the bad actors in the nursing home industry at the expense of seniors and persons with severe disabilities, and no facility should be allowed to get away with abuse and neglect. Large damages call attention to the problems facing seniors in nursing homes and force bad actors to improve their practices in a way that capped damages cannot. We should not protect nursing homes that abuse and neglect elderly residents. We should punish these bad actors and side with the victims and their families, who for the rest of their lives will suffer as a result of negligence. We should not add to their suffering. And I hope that you will support my amendment to exempt lawsuits against nursing homes from the $250,000 cap on non-economic damages. And I yield back.
Gentlelady yields back her time. Are there other members wishing to speak? Gentleman from Texas, Mr. Olson.
I thank the chair. And I speak in strong opposition to this amendment, which excludes nursing homes from the protections contained in H.R. 5. I fail to see why we should support an amendment that will decrease senior citizens' access to long-term care. A well-respected risk consulting firm found that in states that have passed meaningful medical liability reforms, the liability costs have dropped significantly post-reform. Furthermore, both the frequency and severity of claims decreased in states that have passed tort reform. Let me tell you about my home state of Texas, which enacted comprehensive tort reform in 2003. According to a study conducted by Aon Risk Consulting, a well-respected risk consulting firm, data collected in the 2 years after post-medical liability reform in Texas reveals that the average loss cost for nursing home providers has reduced significantly. In the years leading up to the enactment of liability reform in Texas, nursing home providers submitted claims at a rate 2 to 3 times the national average, 2 to 3 times what the nation was doing. The Texas Association of Homes and Services for the Aging estimated that the premiums had increased on average from $328 per bed in 1998 to almost $3,000 per bed in 2002, 1 year prior to reform. A 10% increase, not 10%, I'm sorry, I apologize, a 100% increase in 4 years. A study by Aon found that the average loss cost per occupied bed peaked at $6,720 in 2002 and had already declined to $3,090 by 2004, a 50% reduction in 2 years. Loss costs are trending down in Texas, and industry experts credit medical liability reforms passed in 2003 for these reductions in stabilizing the medical liability market in Texas. Nursing homes are intertwined with the current medical liability crisis, and by excluding them for H.R. 5, my Democrat colleagues are jeopardizing this nation's elderly and frail citizens' ability to find a nursing home that provides quality care and a comfortable home. 2 weeks ago, I met with members of the Houston medical community and talking about this issue, specifically this issue. And they were unanimous that nursing homes would have closed without meaningful tort reform in my great state. The reason? The nursing homes could not have purchased insurance. It was not cost effective. Therefore, they would have had to refuse, shut their doors. Again, this is not what we cannot turn our backs on our nation's elderly at this time. I urge the members to oppose this harmful amendment.
There are other members wishing to speak on the amendment? If not, gentleman from Georgia.
I'd like to yield to the lady from Illinois, Ms. Jakowski.
You know, you've been so interested in changing Medicare and into a new kind of plan that hands them over to the insurance industry and let seniors fend for themselves and trying to get health care. Well, now we've got a situation here where in order to get health care, then seniors that go to nursing homes have to submit themselves to allowing for malpractice. This is absolutely, your argument is so contrary to what experience has been around the country in nursing homes. I mean, are we now declaring a right for seniors to have to be in nursing homes and get maggots so that they have to have their limbs removed? I mean, what kind of a country are we that doesn't hold accountable the people that have repeatedly? Now, we can weed out the bad actors with this with legislation that allows bad actors to be sued and to get them out of the nursing home business or to make them correct their ways. You know as well as I do that in state after state, in every single state, that we have nursing homes, particularly those who have lower income people that are at their mercy, that these kinds of things happen. I would think that the good nursing homes would welcome the opportunity to get rid of these bad actors and not want to let them hide behind the good operators. You know, this is a very limited piece of amendment to this bill. And now to say that as a price for getting into a nursing home, that elderly people have to now submit. Is this a new kind of defined contribution for elderly people, that they have to submit to allowing malpractice to be exacted out of them? And I just think that all of us have had an experience enough with loved ones in our own districts that we know that this is a national problem, and that the way to achieve it is not to limit the liability of nursing homes who, on a regular basis, some of them, are abusing in the worst possible way and causing the premature death of many elderly people while they suck money from the government through Medicaid as well as through the individual. So it seems to me that we ought to be able to, on some level, not just knee-jerk oppose any amendment that comes over from this side, but to work together so that we can make sure that this place of last resort for people, that nursing homes, which are the end of the line, are places that we know are going to be safe. And by limiting liability, we are opening the door. We're saying we're going to let those kinds of things happen. I just think it's surprising to me that you strongly oppose this amendment and make it as if now we're going to prevent seniors from going to nursing homes. It hasn't prevented seniors from going to nursing homes in the past, but now you want to make it easier for them to be abused. I yield back.
Gentleman from Georgia still has the time. Gentleman yields back. Are there other members wishing to speak? Mr. Guthrie.
Thank you, Mr. Chairman. I'll yield time to Mr. Olson from Texas.
I thank my colleague from Kentucky. And with respect to the comments from my colleague from Illinois, ma'am, you know that everything in this bill, H.R. 5, every injury that anyone suffers is compensated, fully compensated under the law. There's 100% liability for the compensatory damages. What you're addressing is the punitive, the non-economic damages. And those are the damages that are hurting our healthcare system. Again, I've talked to the experts back home just 2 weeks ago, and they brought up the fact that nursing homes would have had to close if they had to cover the liability that they were facing from these punitive, the non-economic damages. Again, I agree with you completely. We don't want to close these facilities. We want to make sure that our elderly have the hospitalization and medical care, the quality of life that we expect them to. But having, not having a cap on punitive damages, the non-economic damages, is going to do just that. It's going to close down facilities, and we don't want that. And that's why I strongly oppose this amendment.
Will the gentleman yield?
Yes, sir.
Is the gentleman aware of the difference between non-economic damages on the one hand and punitive damages on the other? Is the gentleman aware that punitive damages are genuinely non-compensatory in the sense they're not trying to make the victim whole for something? They are intended to deter and punish really bad behavior. It's the difference between negligence and murder. On the other hand, non-economic damages are, in fact, compensatory damages, damages that are to compensate the victim for things for which there is no market value, like the cost of a wheelchair or something like that. In other words, the value of your lost limb, the value of your arm, and the value of a bodily function. All of those things are non-compensatory. They're compensatory damages, but they're non-economic damages because they're not measured in the marketplace. They're not bought and sold off the shelf. So the gentleman's comments about equating the two, non-economic damages and punitive damages, is really not accurate. It's not.
I reclaim my time, sir. And thank you very much. I appreciate the lawyerly scholaring. And again, I mean, maybe if I'm not using the right terms, but the bottom line is there are two system damages in our country, in our tort system. There's compensatory damages for your actual injuries.
And non-economic damages are a form of
to
compensatory
change
damages.
And then punitive damage, which are designed to punish. It's not really designed to fix what's happened in the treatment room. It's designed to send a message out to society.
And if the gentleman will yield, there are two limitations in this bill. There's a limitation on punitive damages, and there is a limitation on compensatory non-economic damages. And there are two separate caps to two separate items of damage.
Exactly.
So it is not accurate to say it doesn't apply to compensatory damage.
Reclaiming my time. Under this bill, there is no. If you've suffered injuries, you will be compensated for your injuries just as our tort system is done. Yes, sir.
Not under this bill.
No, sir. Wait, no, let me keep this in my time, please. The punitive damages, those are the ones that are drowning our system. Those are the ones that are making our health care, our nursing homes look at their future and decide whether or not they can do it. Those are the ones that the trial lawyers are attracted to. They're the ones that take about 90%. They get about 90%, 80% of that money. It doesn't go to the patients. The patients get their compensatory damages. And again, this has worked in my great state of Texas. We've got the documentation to show it. I think I've enlightened the committee here about that. And again, I'm greatly opposed to this amendment and yield back my time.
Chairman yields back his time. Are there other members wishing to speak? If not, the vote occurs on the amendment. All those in favor say aye.
Aye.
All those opposed say no. No. Noes appear to have it. Noes have it. The amendment is not agreed to. Are there other members wishing to offer an amendment? Yes. Gentleman, Chair recognizes Mr. Waxman.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the title.
Which amendment?
It's on medical products.
Do you have the number up at the top?
Is there a number on this thing?
We have 130.
Medical products,
136.
Yeah.
136.
At the top, 136.
The clerk will report the title of the amendment.
An amendment to H.R. 5 offered by Mr. Waxman.
Is this the medical products devices amendment?
Strike medical products.
That's it.
Down there.
That's it. The amendment will be considered as read, and the gentleman from California is recognized for 5 minutes in support of his amendment.
Thank you, Mr. Chairman. This amendment would delete FDA-approved drugs and devices, or as the bill refers to them, medical products, from the scope of H.R. 5 entirely. Lawsuits involving drugs and medical devices are not the kinds of cases that are traditionally considered medical malpractice, which is ostensibly the subject of the bill. We usually think of medical malpractice cases as those between an injured patient and his or her treating physician. Instead, these cases are filed by patients who are injured and often killed by defective drugs and medical devices against massive, extremely well-resourced pharmaceutical or medical device companies. The many justifications we hear for why H.R. 5 is necessary simply don't apply when it comes to lawsuits relating to FDA-approved drugs and medical devices. For instance, H.R. 5's proponents say the bill is necessary because it will curtail the practice of defensive medicine. They say the bill will reduce the skyrocketing medical liability insurance rates. They say the bill will address the doctor shortage caused by liability exposure. I've yet to hear the proponents advance an argument as to why we need to include cases against pharmaceutical and medical device companies in this bill. To sweep these cases into the bill without any kind of exploration into why we should is to give the pharmaceutical and medical device industries a major and unwarranted gift. It's also dangerous. FDA has historically viewed state lawsuits as providing a valuable complement to the agency's regulation. FDA has said that they FDA has said that they help to uncover post-market safety risks that are unknown to the agency at the time of approval. A former chief counsel stated FDA regulation of a device cannot anticipate and protect against all safety risks to individual consumers. Even the most thorough regulation of a product, such as critical device, medical device, may fail to identify potential problems presented by the product. Regulation cannot protect against all possible injuries that might result over time, end quote. And that's from a former chief counsel at FDA. Unless we have a system in which FDA itself takes over the drug and device development process, manufacturers will always be in a better position than FDA to know the safety profile of their products. They developed and manufactured the products, they receive the safety reports first, and they are required to alert FDA to any risks they uncover. FDA, on the other hand, is responsible for overseeing the safety of tens of thousands of drugs and medical devices. The Supreme Court recently recognized this predicament as well in upholding the ability of injured patients to sue drug companies for their injuries. The court stated, quote, "The FDA has limited resources to monitor the 11,000 drugs on the market, and manufacturers have superior access to information about their drugs, especially in the post-marketing phase, as new risks emerge," end quote. Well, the bill before us would remove the tort system's invaluable layer of consumer protection at a time when FDA's ability to assure the safety of our drugs and medical devices is in great peril. The Republicans' budget resolution calls for a return to fiscal year 2008 funding levels for discretionary funding across all government agencies. For FDA to return to that level would mean a budget cut of over $600 million, almost 20% of the agency's total budget. Cuts of this magnitude to the FDA's budget will only make worse the agency's inherent difficulty in monitoring the post-market safety of thousands of FDA drugs. The American people deserve better than this. The proponents will argue that the bill is not preempting these cases completely. The lawsuits may still go forward, albeit under the restrictive scheme imposed by the bill. But as Professor Wolfman testified at the hearing, the many restrictions in H.R. 5 will make it difficult, if not impossible, for patients injured by drugs and medical devices to even retain attorneys who will be willing to take their cases. So I would submit it's irresponsible and dangerous to sweep these very different cases into the scope of this bill, especially when there is no coherent rationale for doing so in the very first place. I urge members to support this amendment. I'd be happy to answer any questions that members may have about it.
Chair would recognize Mr. Shimkus from Illinois.
Thank you, Mr. Chairman. To speak against the amendment. This is really an important debate because the point being in the legislation is that if someone is using a authorized legal product certified by the FDA, whether it's a pharmaceutical drug or a device that's been vetted as safe, all that we have in the system, what we're trying to correct is in the liability system where the lawyers are going after all the deep pockets, whether it's a pharmaceutical industry, whether it's a device manufacturer. They're just going after, and we've seen the lawsuits, they sue everybody. And the case is if the pharmaceutical product was properly prescribed and administered, and the device was appropriately administered, then they should not be held in this process just because they have the deep pockets. You know, punitive damages should be reserved for the egregious conduct, and we had that debate earlier. They have no place in cases involving perfectly legal product and legal conduct in which there is full compliance with all FDA safety and effective requirements. It really goes back to the debate we had earlier today about shouldn't there be a standard of care? And if the healthcare industry has proven a standard of care, then they should not be held and sued if they've done everything right. Well, the argument in this case is the pharmaceutical drugs have been vetted by our federal agency. The devices have been tested and proven and said, use these things. Now, this doesn't address the physician or the doctor who may do something wrong in administering, but it doesn't give the plaintiff the right to go after a legal product legally prescribed. And so that's why, you know, we, in essence, I oppose this amendment. I hope my colleagues will oppose this amendment because this does add a cost and is going after industry for producing legal products that have already been vetted by the national government and by our Food and Drug Administration.
Will the gentleman yield?
I would be happy to yield.
This is a situation where the FDA approves a product, and we want them to approve these products as quickly as possible, and they look at the safety, they look at the efficacy. But they can't really we can't expect them to be able to know all the potential harm that could come with this
If the
product.
gentleman would, if reclaiming my time, that's true. But it's not the drug itself, or it's not the device's fault. It may be the practitioner's fault. But you don't sue the pharmaceutical company for the practitioner misusing the drug. You don't sue the device manufacturer for the practitioner maybe abusing the product.
Well, let me give you an example where you might.
And I will yield time to my colleague.
Let's say there's a drug and it's been approved by the FDA, but then we're starting to see that this drug has some harmful side effects when it's used in a very large population. And the manufacturer may know that.
Reclaiming my time, then I would probably say that maybe the FDA ought to recall that product. If there is now evidence that this product is not legitimate, then the FDA ought to say, hey, bad product, get it off the shelves, do something else.
Well, what if the
manufacturer... It's not the drug's fault until the agency says, hey, they've said, use it.
If the gentleman...
I would yield.
The company may know about the problem, but the FDA may not. And therefore, the company may well act in a negligent way in letting FDA know and acting on their own to be responsible.
Reclaiming my time, I think it's under the rules and regulations that if the industry knows of this and doesn't disclose it, then they're at fault. Then you've got some punitive legal court cases against them. I mean, they have to disclose that.
Patients are still harmed by those drugs, and there could be a lawsuit. But then you get all these limitations that we have in this bill relating to doctor-patient relationship, protecting.
And reclaiming my last 10 seconds, if they don't report this, then there's punitive damages under the bill. And I yield back my time.
Other members wishing to seek time?
Mr. Chairman,
Mr. Pallone.
yield my time to Mr. Waxman.
Gentleman is recognized, Mr. Pallone, for 5 minutes, who yields Mr. Waxman.
There are two ways this issue has come up, and one, it was a preemption completely. If it's been approved by the FDA, then the states are preempted from allowing lawsuits to take place with regard to the drug that turns out to be harmful with the negligence of the manufacturer as a cause for the harm. We had a situation where Dennis Quaid, the actor, found that his newborn baby in Los Angeles was given a drug, the wrong dose of a drug, and I don't remember all the details, but he wanted to pursue a lawsuit, and he was told, no, you can't. The drug's been approved by the FDA. Here, we can allow a lawsuit, but there can be limits on the damages. And let me tell you why this is different in this case. The drug companies are substantial organizations. They can fight lawsuits because they have a lot of money to fight them. If an injured party wants to bring a lawsuit against a drug company, they have to look for a lawyer on a contingency basis. Some of these cases can be drawn out for years, and the expenses can be enormous for the injured party's lawyer to be able to even take the case on a contingency basis and hope to recoup their investment in this case and trying to pursue it. And therefore, a lot of people will not take the case. These are not the kind of limitations that make sense for pharmaceutical and medical devices, where you may think they make sense for a doctor, where a doctor may be sued for a frivolous lawsuit or may well be sued, but there's a lot more sympathy for the doctors picking up and moving to another state. Here we have a drug company who have substantial amount of money just simply to drive the lawsuit in a way that would deny the ability, especially if there's such limits on punitive damages. Let's say the company knew that they were doing was harmful, and they should be subject to punitive damages, but there's such a limit on the punitive damages that it's not going to be much money to really be a disincentive for those companies to act the way they may under certain circumstances. So I don't think it's appropriate to have this kind of application to drugs and medical devices in a bill that deals with medical liability for the doctors and the nurses and the podiatrists and all the other health professionals. These are not health professionals. They're big, major corporations, and they have a disadvantage on, they have an advantage on their side and a disadvantage for the plaintiff when there are these limits on damages. And I don't think it's for the federal government to tell states that they ought to have those kinds of limits, because Washington decided that an FDA approval amounts to much more than it does in reality. FDA approval is a tentative judgment that a drug should go to market and be sold. And we want that approval, even though we want continuing monitoring of that drug, and that monitoring often depends on the pharmaceutical company or the device manufacturer participating with the FDA. But the FDA is not equipped to follow all the liability situations, and we ought not to say that they've reviewed all these liability cases in advance. If they had to, the FDA would take an enormous amount of time before they approved these products and got them on the market. And that would be, I think, a bad result, because we want people to have access to the products as quickly as possible, and then a post-surveillance of these drugs or devices to be sure that when we learn more about them, we modify the warning labels, or we modify the way that they're sold, or modify the way that they're manufactured to be sure to keep up with the latest information. If the drug company has the latest information and FDA doesn't, and the drug companies don't own up to it, they may well try to withhold that information, and in the meantime, patients can be injured. And we shouldn't put them under these kind of severe limitations under one-size-fits-all federal law. So I urge support for the amendment.
Chair would recognize Mr. Bilbray for 5 minutes.
Thank you, Mr. Chairman. And Mr. Chairman, I personally met with Mr. Quaid about his case, and I hope that we learn from that, and especially with the fact the gentleman from California was talking about making sure the FDA expedites their process. They've doubled their review time for medical devices in the last 24 months. And maybe we ought to be bringing that about, talking about if they spent more time worrying about safety and less time looking at rationing care by saying that, oh, it's not cost effective to use this device. Maybe we could be able to be talking about it more openly. But the issue with Mr. Quaid was classic, because it wasn't a case of the drug company was wrong. It was the labeling that was approved by the FDA. It was the labeling that wasn't read by a nurse, and it wasn't the drug company at all. So if you want to reinforce this, but let me get around on the other side of this. This is one issue you don't talk about. You had a device, you had a treatment, Vindictin, that was used by women all over this country. There was a national inquiry story in 79. It ended up being lawsuit after lawsuit after lawsuit with no scientific data, according to the FDA, to take it off the market. But sheerly by the harassment of litigation, this product is no longer available to women across this country. And my wife was one of those that went into intensive care while she was in her first trimester of pregnancy, because the litigation drove that product off the market and denied her access to that product. And you know what physicians do now? I don't need to ask these physicians here that are sitting here. They prescribe the two components of Vindictin separately, because the private sector cannot provide it, because it was driven off the market through litigation, not through science. So this does have an effect. It has an effect on what's available for consumers. And I say this, as I said to Mr. Quaid, who do I get to sue? Who do I get to take to trial for those who drove this product off the market? Who do I get to point the finger at? Which lawyers do I get to litigate with that drove it off the market because my wife didn't have the product that she had in her previous pregnancies? She didn't have the ability to get the medication that was essential to not only her, but her unborn baby. Who do I get to have justice with because this product was driven off? That baby died of crib death three months after her birth, and everybody who knows crib death knows one of the most important components is the development in the first trimester of the central nervous system. And I don't get the right to be able to sue the men and women that want their babies born healthy and do not want their wives to go through the morning sickness that my wife threw. We don't have the right to buy that product today. And it wasn't the FDA that took it off the market. It was lawyers that saw deep pockets, litigation, a lot of money, and not talking about what about products that are needed to be out there.
Gentleman,
And
yield.
how many are being lost? And I just say that if we want to think that litigation's the way you do quality, I'm just saying to the gentleman from California, you get a lot of people making money driving products off the market, but how many of them are held responsible? How many of those lawyers are sued when those good products are on there? Thank God there are products out there that were on the market long enough to where litigation. But National Enquirer and trial lawyers deny women the right to be able to do that. So now they get it bootlegged to them by their physicians by having two separate pieces of treatment rather than having the single one that was used was
Gentleman,
effective
yield.
and safe. And effective and safe according to the Drug Administration. I'll yield to the gentleman from California.
I don't know what the gentleman's talking about. If you're talking about thalidomide, there are a lot of drugs.
Excuse me, I'm talking about Bendictin.
And what was the situation with that?
Will the gentleman yield?
Excuse me. Yeah, the gentleman.
Yeah, yield to.
Bendictin was an anti-nausea medication that was available for early pregnancy. Last prescribed it in the mid-1980s. It was a combination, I believe, of vitamin B6, glucose, and some other very mild anti-nausea medication. It was very effective for reasons that no one ever really could adequately explain in the combination that was sold. The components, if you prescribe them individually, don't seem to have the same effect. But there was a child born with a limb reduction defect. The medication was prescribed to be given during the first trimester of pregnancy. That's when hyperemesis is a problem. During the first trimester, there's no other time that you would use it. In the PDR at the time, it said it was indicated for use of hyperemesis in the first trimester of pregnancy. Because of that, and because of a child born with a limb reduction defect, sad case to be sure, but limb reduction defects, an isolated single birth defect, does not a
But
serious
reclaiming
thing.
my time, my wife's physicians had to find old Bendictin that had been taken off the market to be able to administer it to her to get her out of intensive care. That's how important some of this stuff is. But I don't have a right to litigate. I didn't have a right to litigate on this issue. So this works both ways. There is a price to this litigation.
Gentleman's time has expired. Are there other members wishing to speak? I go to the Democratic side first. Other members? Dr. Gingrey actually had his hand up before you, Mr. Lance. Dr. Gingrey.
Mr. Chairman, I thank you. And my colleagues, Mr. Bill Bray and Dr. Burgess, in talking about that particular product, as an OBGYN physician, a little bit older than my colleagues, I know full well about the Bendictin story, and of course that particular medication was just simply, it was prescription medication, but it was a combination of an over-the-counter vitamin, I believe B6, and an over-the-counter antihistamine. They're absolutely right in regard to a perfectly safe drug that could be obtained over the counter. In fact, when it was taken off the market because of all of these frivolous lawsuits, and the company went out of business, I think, doctors just told the patient, go by the drugstore and pick up vitamin B6 and this antihistamine and take it for nausea of the first trimester. But getting to the specifics of the Waxman amendment, of course, I'm very much opposed to it. Paragraph 1 of the bill under exceptions very clearly says a person before or after pre-market approval, clearance, or licensure of such medical product knowingly misrepresented to or withheld from the Food and Drug Administration information that is required to be submitted under the Federal Food, Drug, and Cosmetic Act of the Public Health Service Act that is material and is causally related to the harm which the claimant allegedly suffered. There would be no limitations there would be no cap on punitive damages or or pain and suffering in such situation. So, you know, I really don't see the point of this. These companies, medical device manufacturers, pharmaceutical companies, they're struggling to create jobs because of uncertainty at the FDA. Obamacare's billions of dollars in drug and device taxes. If we allowed this amendment, will further hurt job creation, will hurt innovation and patient access to life-saving, life-improvement drugs and devices by allowing certain, not every, but certain trial lawyers to use these innovative companies as their personal piggy banks, money that can be used for research and development on life-saving devices and drugs will go to defend frivolous lawsuits. If drug and device manufacturers are not covered by the bill, then the cost of these products will continue to rise, perhaps causing these life-saving drugs and devices to become cost prohibitive for many patients. We should be looking for ways to lower the cost of prescription drugs, medical devices, health care in general. That's one of the main purposes, of course, of this medical tort reform legislation. That and what we talked about earlier in regard to physician workforce and not having the subspecialists, the super specialists, the neurosurgeons, and the emergency room physicians at Tucson Medical Center, as an example. And if we continue to just say that, well, you know, the little doc in rural America that's a one-house shop that is working 80 hours a week and taking care of our moms and pops and grandparents, that we're compassionate for him or her, but not so compassionate to a big company that manufactures prescription drugs like Bendectin or some very important medical device that's gone through all of the processes and the phases and the clinical trials and studies that are required by the FDA. They've dotted all the I's, crossed all their T's, and then come back and because after the fact something goes wrong to just use them as I say, a personal piggy bank. It's absolutely inappropriate, and it would defeat this amendment. The passage of this amendment would defeat the purpose of this bill, and I strongly am opposed to it. I encourage my colleagues on both sides of the aisle to vote against the amendment, and with that, I yield back.
Yeah. Gentleman's time has expired. Are there other members wishing to? Oh, I'm sorry. Any Democratic members wishing? Mr. Lance is recognized.
Thank you very much, Mr. Chairman. From my perspective, the FDA defense means that a manufacturer cannot be punished when it does not deserve to be punished. Under this defense, a manufacturer is not liable for punitive damages if it has satisfied FDA's rigorous approval process, and if the harm to the patient does not result from the company's violation of the FDA regulation. From my perspective, and I, at one point in my career, did practice law, punitive damages should be reserved for egregious conduct that shocks the conscience. I do not believe that punitive damages are appropriate involving perfectly legal conduct in which a manufacturer submits full documentation of the drugs or of the medical device's safety and effectiveness to the FDA and markets its drug or medical device only after the FDA independently determines that the drug should be made available to patients. Without this defense, it seems to me that plaintiffs in medical malpractice lawsuits would name as defendants any deep-pocketed pharmaceutical or medical device manufacturer whose products are involved. And in that case, the company could end up shouldering the burden of a significant punitive award when its own conduct has been perfectly legal. Patients who are hurt during medical procedures have the right to sue whoever has hurt them, the physician or a nurse, and they tend to sue hospitals as well. A company that has complied in good faith with the FDA's regulations is not guilty of willful, flagrant, malicious, or grossly illegal behavior when a physician or a nurse or any other person uses its product negligently. In my judgment, it should not be threatened with punitive damages, and for that reason, I respectfully oppose the amendment. Thank you, Mr. Chairman, and I yield back the balance of my time.
Gentleman yields back his time. I'd like to think that we could vote on this. I want to make an announcement to the members as well, and that is that because of this markup taking so long, we are going to mark up the chemical security bill not today. In case anybody's out there and wants to leave, you'll remember that we've done the opening statements. Can we leave now too? You can leave. We've been wondering. We'll actually we'll probably mark that bill up in full committee after the next week. So it's probably 2 weeks, remembering that we've done opening statements. Would also say that we will be doing, rather than doing the opening statements tonight for the health subcommittee markup on maintenance of effort, we will do that all tomorrow. So we'll not do opening statements tonight. And Mr. Waxman and I have had a very good conversation relating to the rest of the amendments. We have tentatively come to an understanding in terms of a time constraint for those amendments, and would like to think that we'll be done pretty close to when votes occur on the floor. If not, we'll come back right after votes on the floor and finish, but it shouldn't be too much after that as we had entered into our discussion. And if there are no other members wishing to speak on this amendment, I'd like to think we could put it to a vote, and the chairman or ranking member would like a roll call vote. So I'll ask the debate is concluded. I'll ask the clerk to ask for the names for the vote.
Mr. Barton. Mr. Stearns. Mr. Whitfield. Mr. Whitfield, nay. Mr. Shimkus. Mr. Shimkus, nay. Mr. Pitts. Mr. Pitts, nay. Mrs. Bono Mack. Mr. Walden. Mr. Terry. Mr. Terry, nay. Mr. Rogers. Mrs. Myrick. Mr. Sullivan. Mr. Murphy. Mr. Murphy, nay. Mr. Burgess. Mr. Burgess, nay. Mrs. Blackburn. Mrs. Blackburn, nay. Mr. Bilbray. Mr. Bilbray, nay. Mr. Bass. Mr. Bass, nay. Mr. Gingrey. Mr. Gingrey, nay. Mr. Scalise. Mr. Scalise, nay. Mr. Wada. Mr. Wada, nay. Mrs. McMorris Rogers. Mrs. McMorris Rogers, nay. Mr. Harper. Mr. Lance. Mr. Lance, nay. Mr. Cassidy. Mr. Cassidy, nay. Mr. Guthrie. Mr. Guthrie, nay. Mr. Olson. Mr. Olson, nay. Mr. McKinley. Mr. McKinley, nay. Mr. Gardner. Mr. Gardner, nay. Mr. Pompeo. Mr. Pompeo, nay. Mr. Kinzinger. Mr. Kinzinger, nay. Mr. Griffith. Mr. Griffith, nay. Mr. Waxman. Mr. Waxman, aye. Mr. Dingle. Mr. Dingle, aye. Mr. Markey. Mr. Towns. Mr. Pallone. Mr. Pallone, aye. Mr. Rush. Mr. Rush, aye. Ms. Eshu. Ms. Eshu, aye. Mr. Engel. Mr. Engel, aye. Mr. Green. Mr. Green, aye. Ms. DeGette. Ms. DeGette, aye. Mrs. Capps. Mr. Doyle. Mr. Doyle, aye. Ms. Schakowsky. Mr. Gonzalez. Mr. Inslee. Mr. Inslee, aye. Ms. Baldwin. Ms. Baldwin, aye. Mr. Ross. Mr. Ross, aye. Mr. Weiner. Mr. Weiner, Aye. Mr. Matheson. Mr. Butterfield. Mr. Butterfield, aye. Mr. Barrow. Mr. Barrow, aye. Ms. Matsui. Ms. Matsui, aye. Ms. Christensen. Ms. Christensen, aye. Mr. Upton. Mr. Upton, nay.
Other members wishing to cast a vote. Mr. Stearns.
Mr. Stearns, nay.
Mr. Walden.
Mr. Walden, nay.
Bono Mack.
Ms. Bono Mack, nay.
Mr. Harper.
Mr. Harper, nay.
Mr. Matheson.
Mr. Matheson, nay.
Are there other members wishing to cast a vote? If not, the clerk will report the tally. Oh, Mr. Barton. Mr. Barton votes no.
Mr. Barton, nay. Mr. Upton?
Yes.
17 ayes, 29 nays.
17 ayes, 29 nays. The amendment is not agreed to. Other members wishing to offer an amendment? Mr. Pallone.
Mr. Chairman, I have Pallone Amendment number 1 at the desk.
The clerk will report the title.
An amendment offered by Mr. Pallone of New Jersey.
I think gentleman is recognized for 5 minutes in support of his amendment.
Thank you, Mr. Chairman. My amendment is quite simple and, in my opinion, a common sense and realistic approach to placing caps on awards to patients harmed in medical errors. The language increases the $250,000 cap on non-economic damages in the underlying bill, which is based on a California law passed in '75, to reflect what that value is today. That amount is equal to about $1 million and is based on the Consumer Price Index inflation.
Would the gentleman suspend for a moment? I think that the gentleman meant to bring up Pallone Amendment number 2.
Mine says number 1, but let me see.
The amendment that they're circulating was the one that we had for number 1. Is it irreversible injury?
No, if you say it's number 1, I'd take your word for it. I mean number 2.
So we'll restart the clock, and we'll ask the. This is the one that he's.
Why don't we clarify it, Mr. Chairman, before we proceed?
Yeah, yeah.
It's the 1 million.
No, is it the 1 million?
CPI.
Oh, that was. I think it's. We actually had it on our side as Pallone number 3. Is this the $1 million cap?
Yes.
Yeah, that's amendment number 3. Okay.
Okay.
All right. Gentleman is recognized for 5 minutes in support of his amendment.
Thank you. I don't want to repeat it. I mean, basically, we're going from 250 to $1 million, and that is what would happen if you went from 1975, which was when the California law was passed at 250, and you used the consumer price inflation factor. It would be essentially $1 million today. It also includes the same inflation adjuster based on the consumer price index so that the amount of the cap can be indexed annually. Mr. Chairman, we must not forget that medical malpractice reform affects patients. Any true reform must take a balanced approach and include protections for the legal rights of patients. Medical malpractice in the U.S. has devastating consequences. It's the 6th leading cause of death in this country. In addition, a November 2010 study by the Office of the Inspector General of the Department of Health and Human Services found that approximately 1 in 7 hospital patients experience a medical error, 44% of which are preventable, and that these errors cost Medicare $4.4 billion per year. Now, H.R. 5, which, as we all know, is the same identical legislation we've considered it for the past decade, is based on the '75 California law known as MICRA, and that includes MICRA's monetary caps on non-economic damages. So let me be clear, in case there was any question. These caps are based on amounts created 36 years ago. We can't continue to consider this ridiculously low and arbitrary cap on non-economic damages. I think we all realistically know that $250,000 is unworkable and unrealistic. I even think that some of our doctors, in fact, some of them have told me that they would agree and would be willing to negotiate on that number. While a $250,000 cap might have been reasonable when enacted, it's not reasonable today. The cap would also have a devastating impact, that's the $250,000, on children and the elderly who are not in the workforce and thus do not suffer economic loss, such as lost wages or salary. For example, if a medical error or medical neglect were to result in the death of a child, the child's parents may not be able to bring a wrongful death lawsuit because the cost of the case is substantial compared to the amount of the potential recovery. There's no economic loss since the medical costs were covered under the parent's insurance coverage and the child has no lost wages or income. Then the most that the parents can recover for their devastating loss is $250,000, regardless of how egregious the malpractice. The cap removes any incentive, that's the $250,000, removes any incentive to reduce the number of medical errors because the amount of damages can be calculated as the cost of doing business. And lastly, you can't address true malpractice reform, in my opinion, without controlling the rising premiums for insurance. By imposing caps on non-economic and punitive damages, that doesn't do anything, in my opinion, to rein in these rising premiums. But my main point here, Mr. Chairman, and I made it during the subcommittee hearing, and I've made it many times to my colleagues, is that this is one of the things that makes this bill unreasonable, such a low cap. I know people have been fixated on this $250,000 for decades. I have no idea why. It just doesn't make any sense anymore given what's happened over the last 36 years. And I don't know if anybody else would like to take my time. Otherwise, Mr. Chairman, I will yield back.
Gentleman yields back. I would just like to note that Mr. Waxman and I agreed that we would spend 15 minutes on this, 7.5 on each side. On our side, Dr. Gingrey is recognized.
Mr. Chairman, thank you. And I won't take the full 5 minutes. I'm very much opposed, of course, to the Pallone amendment, which would, as he explained, raise the cap on non-economic damage to $1 million and index it to the Consumer Price Index. This amendment, if passed, would remove much of the benefit from the main cost-saving and stabilization provision of the bill. In 2005, 6 years ago, an analysis in California found that if the caps were doubled from $250,000 to $500,000, it would increase the cost of the healthcare system in that state by $6.2 billion. So if we increased to $1 million, I guess it would increase the cost in that state to $12.4 billion. The main point is that non-economic damages are not awarded to pay for goods and services, and they really have no relationship to the Consumer Price Index. So any increase in caps comes with a trade-off of increased cost and reduced access to care. And I guess my last point, and maybe the most significant, the bill is very clear in stating that the caps in the individual states, either existing or in the future, can be higher or can be lower. And our legislation in H.R. 5, the Health Act, in no way prevents that. In fact, a state could, if the legislature decided, could say the cap on non-economic or punitive is $100 billion, it could, any number, infinity. They could do that if they, in their infinite wisdom, decided that that was appropriate. Again, I just feel like that this amendment will undo so much of the stabilization that we're looking for in regard to the predictability, which leads to, of course, what the medical malpractice insurance industry uses in trying to determine their insurance rates.
Will the gentleman yield?
I'll be glad to yield to my colleague from New Jersey.
I came up with $1 million based on the Consumer Price Index. I mean, you can use other things if you want. The main thing, you know, I said at the hearing, and I've said to some of my colleagues on the other side of the aisle for years, if you really want to come up with a way of dealing with this issue, you have to raise the cap because it's unrealistic, you know, 35 years ago. You have to limit this reform to malpractice, not throw in, you know, tort reform for everything but the kitchen sink. And you have to do what Mr. Waxman constantly says, which is that you have to have some way of actually controlling or regulating prices the way they do in California. If there was an effort on the part of the Republican side of the aisle to try to meet us on these things, then I think we could actually come up with something that we might actually come up with a consensus on.
Well,
but I think that when you stick with the 250, it's just not realistic.
Well, reclaiming my time, the gentleman from New Jersey didn't make this comment, I think, earlier, but I think one of the members on his side of the aisle from New York did, and it was something to the effect that, you know, in New York, $250,000 doesn't go very far. You know, it's not a big number. I think that may be applicable as well to the state of New Jersey, the gentleman state which he represents, and I guess maybe they need to talk to President Obama in regard to that, in regard to his opinion on raises taxes on anybody that makes more than $200,000 or $250,000 for a family. I agree. It's you know, it's pretty expensive to live in New York and New Jersey. But here again, it has no relationship, the punitive damage or non-economic to the cost of goods and services. That's all calculated in the economic. The other part of the compensatory damages, and certainly inflation affects that in these judgments. We've got evidence from California over the last several years of awards that reach $95 million of economic cost due to lost wages and medical care into the future, and yet the limitation exists of $250,000. So I yield back on my time's expired, and I oppose the amendment.
I remind we have 2.5 minutes on each side. Yield to the gentleman from New York.
Thank you. Now, I'll try not to take too much time. You know, the gentleman from Georgia explains that the $250,000 would give more predictability for the liability insurance industry. Is that really what the role is of non-economic damages? Is that really what you're trying to do, is to lend predictability? What you're trying to do with that portion of the damages that a jury would decide is to try to figure out how you create a structure that someone isn't incentivized to say, you know what, we're not going to put a great deal of attention and care into taking care of this patient, because what's the worst that can happen to us? Yeah. You may believe, and maybe there are some of my colleagues who do, that you should never have any non-economic damage. You should never have any punitive damages at all. I got to tell you, we're tiptoeing down to a place where pretty soon you're going to completely federalize the entire state legal regime, and maybe you'll have a chance to do that. But I don't believe that that should be the highest sense of responsibility in the law. Should not be how we give predictability to the liability insurance industry. I can't imagine that the gentleman from Georgia, when he goes home and talks about what he did this week in Congress, says, ladies and gentlemen, I've done it. I have given predictability to the liability insurance industry, and I want you to express your gratitude to me by re-electing me in a couple of years.
The gentleman will yield?
Certainly I would.
I thank the gentleman for yielding, since he referenced me. But no, I won't go home and say that. I will go home and say that in this bill, which will give predictability and bring down the cost of medical malpractice insurance, which will reduce the overall cost of health care in this country. Maybe it's only 0.2% when you figure only the cost of medical malpractice insurance, but when you add the cost of defensive medicine, you get up probably to 3 or 4% of the total cost of health care.
Well, I appreciate it, and perhaps I hung too much on that one phrase that you used because it was kind of jarring, and I think what Mr. Pallone is trying to say here is that, you know what, if we're going to get into this risky business of members of Congress from hundreds of miles away from Georgia and from New York City saying, you know what, we are so superior, we're so smart that we're going to say the amount that is perfect for this purpose, not let juries, not let bench trials, not let judges do it. We're going to do it. And I think that what Mr. Pallone is saying, okay, if we're going to do it, at least let's try to figure out a way that we do it that has the effect that it's supposed to have. And the effect is not.
But if the gentleman would further
Well,
yield.
let me just finish my point, and I'll be glad to yield whatever few seconds I have.
Yeah.
It is not the purpose of his amendment, nor should this law be, to give predictability to the liability insurance industry. It should be to make sure that patients get as good as care as possible, that if someone harms them in a way that the state law is respected, they get a chance to go before a judge, before a jury of their peers, to make the case so we can apportion in a civil way how that responsibility should be portioned out, and also disincentivize someone from making the same mistake in the future. That, in a general sense, is what we should be doing, and I think Ms. Pallone is trying to do that.
The gentleman yield me that 1 second. I think my final point is that under this law, under this bill, the states can do that. They can set that level, that cap at whatever level they want.
There are other members on the Republican side wishing to use the remaining 2.5 minutes. If not, the vote will be on the amendment.
I was going to ask for a roll call, Mr.
Yes,
Chairman.
we'll have an amendment. The clerk will call the roll.
Mr. Barton. Mr. Barton, nay. Mr. Stearns. Mr. Whitfield. Mr. Shimkus. Mr. Pitts. Mrs. Bono Mack. Mr. Walden. Mr. Terry. Mr. Rogers. Mr. Rogers, nay. Mrs. Myrick. Mr. Sullivan. Mr. Murphy. Mr. Murphy, nay. Mr. Burgess. Mr. Burgess, nay. Mrs. Blackburn. Mr. Bilbray. Mr. Bilbray, nay. Mr. Bass. Mr. Bass, nay. Mr. Gingrey. Mr. Gingrey, nay. Mr. Scalise. Mr. Scalise, nay. Mr. Wada. Mr. Wada, nay. Mrs. McMorris Rogers. Mrs. McMorris Rogers, nay. Mr. Harper. Mr. Harper, nay. Mr. Lance. Mr. Lance, nay. Mr. Cassidy. Mr. Cassidy, nay. Mr. Guthrie. Mr. Olson. Mr. Olson, nay. Mr. McKinley. Mr. McKinley, nay. Mr. Gardner. Mr. Gardner, nay. Mr. Pompeo. Mr. Pompeo, nay. Mr. Kinzinger. Mr. Griffith. Mr. Griffith, nay. Mr. Waxman. Is he up there? Mr. Dingle. Mr. Dingle, aye. Mr. Markey. Mr. Towns. Mr. Pallone. Mr. Pallone, aye. Mr. Rush. Miss Eshu. Miss Eshu, aye. Mr. Engel. Mr. Green. Mr. Green, nay. Ms. DeGette. Mrs. Capps. Mr. Doyle. Mr. Doyle, aye. Ms. Schakowsky. Ms. Schakowsky, aye. Mr. Gonzalez. Mr. Inslee. Mr. Inslee, aye. Ms. Baldwin. Ms. Baldwin, aye. Mr. Ross. Mr. Ross, aye. Mr. Weiner. Mr. Weiner, aye. Mr. Matheson. Mr. Matheson, nay. Mr. Butterfield. Mr. Butterfield, aye. Mr. Barrow. Mr. Barrow, aye. Ms. Matsui. Ms. Matsui, aye. Ms. Christensen. Ms. Christensen, aye. Mr. Upton.
No.
Mr. Upton, nay.
Other members wishing to vote? Mr. Pitts.
Mr. Pitts, nay.
Mr. Walden.
Mr. Walden, nay.
Ms. Blackburn.
Ms. Blackburn, nay.
Mr. Terry.
Mr. Terry, nay.
Ms. Bonomack.
Ms. Bonomack, nay.
Mr. Stearns.
Mr. Stearns, nay.
Mr. Guthrie.
Mr. Guthrie, nay.
Mr. Whitfield.
Mr. Whitfield, nay.
Mr. Waxman.
Aye.
Mr. Waxman, aye.
Mr. Towns.
Mr. Towns, aye.
Mr. Engel.
Mr. Engel, aye.
Vote. Yeah. I'm sorry, Mr. Shimkus.
Mr. Shimkus, nay.
Are there other members wishing to cast a vote? If not, the clerk will report the tally. I heard. All right.
Mr. Chairman,
Go ahead.
on that, there are 16 ayes, 30 nays.
16 ayes, 30 nays. The amendment is not agreed to. For what purpose does the gentleman from the great state of Michigan seek recognition?
Mr. Chairman, I have an amendment at the clerk's desk.
Gentleman has the amendment. Which amendment is it?
It's the amendment I just filed.
One. You've got two amendments that I know that are there.
We got it.
One, amendment number one.
What's the number of it? Number one. It's number one.
Number one, the clerk will report the title.
An amendment offered by Mr. Dingle of Michigan.
And the amendment will be considered as read, and the gentleman is recognized for 5 minutes in support of his amendment. Might I ask the parliamentary inquiry of the gentleman, is this the amendment that would make drugs and devices subject to punitive damages if they're misbranded?
Yes.
Gentleman is recognized for 5 minutes.
I thank the chair. I want to commend the staff of both the majority and the minority. The question of punitive damages has been a matter of concern to me. If the drugs are misbranded under the legislation as offered, they would not be subject to punitive damages in the event that there was a lawsuit for negligence or for malpractice. This would affect, of course, as everyone knows, mostly the manufacturers of pharmaceuticals. Having said that, the amendment makes a simple change, and it simply changes it so that where the drugs are misbranded within the meaning of the Food and Drug Act, that they are then subject to, where there's a lawsuit in which the plaintiff prevails, subject to punitive damages. And I'll be happy to yield to any of my colleagues who have a question or a comment. I'm happy to yield to the chairman.
If the gentleman will yield to me, I would just like to say that we are willing to accept the gentleman's amendment.
I thank you,
The
Mr.
purpose
Chairman.
of this section is to say that if manufacturers of medical devices or drugs that comply with the requirements of the Food, Drug, and Cosmetic Act, that they should not be held liable for punitive damages. And if someone is complying with the law and regulations, what actions are we trying to punish when in fact punitive damages are meant to punish? So your amendment clarifies that those that cause a medical product to be misbranded or adulterated can be held liable for punitive damages, and that certainly seems appropriate. I would urge all members to support the amendment and tell the gentleman, as much as I would like to have thought that we might be able to get your vote for final passage, I understand, but your amendment dramatically improves.
I thank the chairman. You are always most gracious, and I seek to be as helpful as I can.
And I will work with our leadership to make sure that this amendment is included on the bill that reaches the House floor through the Rules Committee. Are there other amendments that wish to speak in support of the amendment? If not, all those in favor of the amendment say aye. Aye. Those opposed say no. No. The ayes have it. The ayes have it. The amendment is agreed to. Other members to wish. Other members wishing to offer an amendment. The gentleman again from Michigan has his second amendment that he'd like
Chairman,
to
you
offer.
are most courteous. I have an amendment at the clerk's desk.
And the clerk
It is
will
one
report.
which appears at page 9.
Clerk will report the title of the amendment.
An amendment offered by Mr. Dingle of Michigan.
And the amendment will be considered as read, and the gentleman is recognized for 5 minutes in support of his amendment.
Mr. Chairman, I thank you again. H.R. 5 provides that punitive damages may only be awarded if the plaintiff proves by an impossible heightened standard of clear and convincing evidence that the defendant acted with malicious intent to injure the plaintiff, or the defendant understood that the plaintiff was substantially certain to suffer unnecessary injury, yet deliberately failed to avoid such industry. The amendment would strike this unreasonable standard and replace it with a standard that is already understood and that is already in federal law under the Volunteer Protection Law, Public Law 105-19, a law that provides volunteers with immunity but does not protect them from punitive damages if they recklessly injure others. Requiring patients to prove that the defendant acted with malicious intent makes punitive damages, which are already rare, quite frankly, extinct. Malicious intent requires more than criminal misconduct. Punitive damages are necessary in order to deter the most flagrant abuses, such as doctors operating under the influence of alcohol or drugs, or having sexual relations with patients who are unconscious. The requirement of malicious intent would protect a doctor who was drunk if he killed a patient, because the court would likely hold that a drunken doctor was unable to form the necessary intent. For example, there's another case, and I want to make it very clear. These are very, very rare cases, but they are important because our doctors are almost without exception people of great integrity and decency and concern. But there was a dentist by the name of Dr. Lisa Getz who was wheeled into the operating room to deliver her first baby by a cesarean section. The cesarean section was successfully performed, but the obstetrician stunned the nurses by carving his initials into the belly of the mother. Now, clearly, this is the kind of thing that is the most flagrant indifference to the health of the patients. The amendment would simply ensure that punitive damages, again, which are rare because they are not awarded in cases of simple negligence, are available only where the defendant has committed an act so atrocious and so dangerous that punishment, not just compensation to the patient, is warranted. And I'll be happy to yield to any of my colleagues who have a question or a comment.
Gentleman yield back.
I do.
Gentleman yields back his time. Anyone on our side wishing to speak opposed to the amendment? Dr. Gingrey is recognized for 5 minutes.
Mr. Chairman, thank you, and certainly I appreciate the gentleman from Michigan's amendment and his intent. But I believe that his amendment strikes language, as I understand it, in order to replace it with more ambiguous language. The amendment, referring to the bill, the amendment would strike lines 12 through 15 on page 9 that spell out punitive damages apply to a person that acted with malicious intent to injure the claimant, or that such person deliberately failed to avoid unnecessary injury, and that such person knew the claimant was substantially certain to suffer. It would replace that language with, as we read in the amendment, a person's conduct constitutes willful or criminal misconduct, gross negligence, reckless misconduct, or a conscious, flagrant indifference to the health or safety of the claimant, to the claimant. I think that the language in the bill is clear. I know the gentleman's intent to make it maybe more clear, more definitive, but I think it does just the opposite. And I just think it would lead to more confusion, and at best it's repetitive, and at worst it appears to provide less clarity on intent for courts when deciding whether punitive damages should apply. And again, I thank the gentleman for the amendment. I thank the gentleman for working with us, and I was in favor of his First Amendment, but I will have to respectfully oppose this amendment, and I yield back.
Gentleman yields back. All time has expired. Those in support of the amendment will say aye.
Aye.
Those opposed say no. No. Noes appear to have it. The noes have it. The amendment is not agreed to. I would tell my colleagues it appears as though we have only 4 amendments remaining. And at this time would recognize the gentleman, Mr. Pallone, to offer his amendment.
Thank you, Mr. Chairman. I believe this is Pallone Amendment number 2.
The clerk will report the title.
An amendment offered by Mr. Pallone of New Jersey.
And the amendment will be considered as read, and the gentleman is recognized for 5 minutes in support of his amendment.
Thank you, Mr. Chairman. This amendment eliminates the monetary cap on punitive damages. As Mr. Dingell has mentioned, punitive damages are only awarded in the event of wanton and reckless conduct. By definition, these types of awards are used when a doctor puts a patient's life at risk knowingly. Furthermore, punitive damages are so rare because they're not awarded in cases of simple negligence. Rather, they're awarded by the court only in cases where the defendant has committed an act so atrocious and dangerous that punishment, not just compensation to the patient, is warranted. Despite anecdotal evidence of widespread and unbridled punitive damages awards, the truth of the matter is that punitive damages are extremely rare in medical malpractice and medical products cases. In fact, only 265 medical malpractice punitive damage awards were made in the 30 years between 1963 and 1993 in the United States. In addition, and I think perhaps more important, by basing the punitive damages cap on the level of economic losses, such as lost wages, H.R. 5 discriminates against women, minorities, children, the elderly, and others who tend to have lower incomes. For example, a corporate executive earning $200,000 in salary who was injured due to egregious malpractice would be able to recover as much as $400,000 in punitive damages, yet a stay-at-home parent victimized by identical egregious conduct would be limited to a maximum of $250,000 in punitive damages under the bill. I think that punitive damages are necessary to deter the most flagrant abuses, and I urge my colleagues to support my amendment. Mr. Chairman, before I yield, let me just say, you know, I put this amendment and the one before on the cap up to $1 million before the committee because I really believe that if the Republican side were to adopt many of the suggestions that the Democrats make, and again I go back to particularly the caps and the need to address the actual amount of insurance premiums and have some control over it, and narrowing the focus of this bill to simply malpractice, then I think we might be able to come up with something that would actually move. But, you know, it frustrates me, and I know you say maybe it sounds naive, but it frustrates me that we continue, or the Republicans continue to move a bill that we've moved so many times and goes nowhere. You know, the President has even said many times that he's willing to work with this issue, and I just don't see any effort on the part of the Republican side of the aisle to do anything to achieve a consensus or to work with us on this issue. And I think it's unfortunate. I'm not just saying that because I'm trying to be
with the gentleman
malicious, but I just think that, you know, we keep moving the same bill over and over again, and most of the Democratic amendments are really designed to try to come to up with something that actually might make a difference rather than just moving something that's going nowhere. Yeah, I would yield, certainly.
I just like to remind the gentleman that we did send a letter to the President has been very outspoken in support of tort reform for a number of years. We asked, again, formally a letter that I think we'll put into the record. We'll ask unanimous consent to put the letter into the record, and we received no response back.
Well, I think he said many times in public statements, including, if I'm not mistaken, the State of the Union address, that he would like to work with the other side of the aisle on this and many issues. And I just don't see how moving this bill today accomplishes anything, frankly. But I've said my piece. And anybody
Would the
else?
gentleman yield?
Like, yes, the gentlewoman from the Virgin Islands.
Thank you. I just wanted to thank you for raising the issue of the unfairness of this cap to women, minorities, and the elderly, because really almost all of the provisions that we've tried to amend here today are unfair, from the limiting of the contingency fees to the caps on non-economic damages, as well as the caps on punitive damages. And that's one of the reasons why I as a physician do oppose this bill, in addition to the fact that it really does not resolve the issue of patient safety and reducing medical errors. Thank you. I'll yield back.
Unless someone else wants my time, I would yield back, Mr. Chairman.
Gentleman yields back. Members on our side, Mr. Olson is recognized for 5 minutes.
I thank the chair. I speak in opposition to the amendment from my colleague from New Jersey that would strike limits on punitive damages. Punitive damages are meant to punish the bad actor, not compensate the victim for injury. The punishment should be proportionate to the actions being punished. H.R. 5 allows punitive damages up to $250,000 or twice the economic damages, whichever is higher. There is no cap on economic damages. A couple examples. The following cases from California show that reasonable legal reforms, such as those in H.R. 5, will still allow for very full economic damage awards to deserving victims. In December 2012, a 5-year-old boy with cerebral palsy and quadriplegia was awarded $84 million in economic damages. A 3-year-old girl with cerebral palsy was awarded $59 million in economic damages. Under H.R. 5, these cases would generate punitive damages of $168 million and $118 million, respectively. Unlimited costs are the result of no limits on punitive damages. I've got an example from my district, Texas 22, Kelsey-Seybold. And this is from the president, the chairman and managing director, Dr. Spencer Berthenson. He says, Kelsey-Seybold is a multi-specialty group practice serving 500,000 patients in Houston. And now I'm summarizing here. In 2003, the Texas professional liability crisis was peaking. Kelsey-Seybold was a favorite target of the lawsuits because of the size of the group. They could not obtain professional liability insurance at any price. They were forced to create a self-insurance program. Prior to 2003, when they were self-insured, they were spending an average of $6 million per year in professional liability costs. The number of cases, once tort reform was passed in Texas, the cases against Kelsey-Seybold fell dramatically. And within 2 years, their costs for insurance had dropped to $1 million per year. It went down from $6 million with no limits on punitive damages to $1 million. What did they do with that $5 million? They reinvested over 5 years in the installation of a comprehensive electronic medical record. Just one example of the benefits of putting caps on punitive damages. In addition to punitive damages in a civil case, there are also other remedies to punish the type of intentional or gross negligent behavior that punitive damages are designed to punish and deter. These include solutions within state authority, like revoking a medical license or criminal proceedings. These types of enforcement decisions designed to punish defendants are conducted by appropriate enforcement authorities based off of standards and due process. I strongly oppose this amendment. I urge my colleagues to vote against it.
Gentleman yield. Would gentleman yield to me?
Yes, sir. I yield back to my colleague from Georgia.
I thank the gentleman from Texas. You know, just make a quick point. I was meeting today with one of my local chamber groups from the 11th District of Georgia. We're talking about a local project, economic development, job creation, that's going to be a little bit difficult to pull off, a bit of a heavy lift. And he said to me, Congressman, can't, never could. I say that because a number of my colleagues on the other side of the aisle have said, look, why do you guys, gals, Republicans on the majority side keep pushing legislation that has no ability, no likelihood to pass. Well, you know, you all know the history of William Wilberforce. If he took that attitude, people probably would still be in servitude in the United Kingdom. We don't say that this is not a heavy lift, but we're going to pass this in committee. We're going to pass this out of our committee, and we're going to pass it on the House floor. And we are going to be prepared to work with the Senate to get this bill enacted into law, and work with President Obama as he has pledged and committed himself to medical liability reform, and understands the need and the cost savings and the increased accessibility to health care for all of our patients. And maybe we do that, we wouldn't need a 2,400-page bill, government takeover of health care to allow 10 million people to have access to health insurance, because this in itself would save at least $62 billion over 10 years. And I thank the gentleman for yielding to me.
Thank you. Reclaiming time, Mr. Chairman, I'd just like to ask unanimous consent that the letter from Kelsey Siebold be put in the record.
Without objection. Are there other members wishing to use the remaining time to speak on this amendment? If not, the vote will occur. Oh, gentleman is recognized. Oh, roll call vote. The clerk will, time has expired. The clerk will call the roll.
Mr. Barton. Mr. Stearns. Mr. Whitfield. Mr. Whitfield, nay. Mr. Shimkus. Mr. Pitts. Mrs. Bono Mack. Mr. Walden. Mr. Terry. Mr. Terry, nay. Mr. Rogers. Mr. Rogers, nay. Mrs. Myrick. Mrs. Myrick, nay. Mr. Sullivan. Mr. Murphy. Mr. Murphy, nay. Mr. Burgess. Mr. Burgess, nay. Mrs. Blackburn. Mr. Bilbray. Mr. Bass. Mr. Bass, nay. Mr. Gingrey. Mr. Gingrey, nay. Mr. Scalise. Mr. Scalise, nay. Mr. Latta. Mr. Latta, nay. Mrs. McMorris Rogers. Mr. Harper. Mr. Harper, nay. Mr. Lance. Mr. Lance, nay. Mr. Cassidy. Mr. Cassidy, nay. Mr. Guthrie. Mr. Guthrie, nay. Mr. Olson. Mr. Olson, nay. Mr. McKinley. Mr. Gardner. Mr. Gardner, nay. Mr. Pompeo. Mr. Kinzinger. Mr. Kinzinger, nay. Mr. Griffith. Mr. Waxman. Mr. Waxman, aye. Mr. Dingle. Mr. Dingle, aye. Mr. Markey. Mr. Towns. Mr. Towns, aye. Mr. Pallone. Mr. Pallone, aye. Mr. Rush. Ms. Eshoo. Ms. Eshoo, aye. Mr. Engel. Mr. Green. Mr. Green, aye. Ms. DeGette. Ms. DeGette, aye. Mrs. Capps. Mr. Doyle. Mr. Doyle, aye. Ms. Schakowsky. Mr. Gonzalez. Mr. Inslee. Ms. Baldwin. Ms. Baldwin, aye. Mr. Ross. Mr. Weiner. Mr. Weiner, aye. Mr. Matheson. Mr. Butterfield. Mr. Butterfield, aye. Mr. Barrow. Mr. Barrow, aye. Ms. Matsui. Ms. Matsui, aye. Ms. Christensen. Ms. Christensen, aye. Chairman Upton. Mr. Upton, nay.
Other members wishing to vote? Mr. Barton.
Mr. Barton, nay.
Mr. Stearns.
Mr. Stearns, nay.
Mr. Griffith.
Mr. Griffith, nay.
Ms. Bono Mack.
Ms. Bono Mack, nay.
Mr. Walden.
Mr. Walden, nay.
Ms. Blackburn.
Ms. Blackburn, nay.
Other members wishing to cast a vote? Mr. McKinley.
Mr. McKinley, nay.
Other members? Mr. Inslee.
Mr. Inslee, aye.
Mr. Matheson.
Mr. Matheson, nay.
Any other members? If not, the clerk will report the tally. Okay. Okay. All done. Boom, boom, boom. Okay. Oh, Mr. Shimkus.
Mr. Shimkus, nay.
You ready?
Mr. Chairman, on that, there were 15 ayes, 27 nays.
15 ayes, 27 nays. Let me make one comment, and then I'll yield to Mr. Dingle. We have 3 amendments left. Mr. Towns has 1. Mr. Waxman has 2. We have and Mr. Markey, if he returns. We have a time agreement on all of them. We will roll the votes until after the discussion on all 3, and then have a roll call on final. That's the intent to do. So we have a little time. Hopefully we'll do this all before the votes start. Mr. Dingle, did you seek recognition?
Seek to strike the requisite number of words.
Gentleman is recognized.
I'd like the attention of council, because my purpose here is trying to go into this question of non-economic damages. As I read the bill, it's the ceiling on non-economic damages is $250,000. Is that right? Yes or no?
Cap is $250,000.
Okay. Now, we have an infant, healthy infant, and that infant, through malpractice in the hospital, is rendered a vegetable. Let's go to the amount of damages that a court would give in most states. That child has no discernible earning capacity because of his infancy. Is that right?
No, sir.
He has no discernible earnings capacity. So the result is that child is not going to have any really discernible economic damages.
No, sir. In a civil trial.
What are the economic damages that that infant will have?
Sir, what will happen in a civil trial is the plaintiff's attorney will bring in an expert to testify as to the earning potential of that child throughout its life.
That is a highly conjectural event, because that child has no history of work or earnings. Isn't that right?
No, sir. And if you, Congressman Olson, as he referenced earlier, the big verdicts were a result of that.
Let's go a little further. A housewife who has been a housewife during her whole life has never been employed outside the home. Now, you and I happen to know that a housewife is perhaps the most honorable calling in our society. But unhappily, the courts have not held that her earning capacity is of particular value. So the end result is she is limited, or her heirs are limited to $250,000 because of the cap. What is her earning capacity?
Her earning capacity would be similar to what I defined earlier. You would bring in an expert to testify as to her value.
You are a very wise lawyer, and you're sitting down there and advising me, and you're telling me how this housewife is going to have an earning capacity, or how the child at age, let's say, 3 months, is going to have a discernible earning capacity. What is the earning capacity of that child at age 3 months, or that housewife who has never worked out of the home?
You know, I'm not
give us an intelligent speculation upon what that number might happen to be.
Yeah, I'm not going to get into conjecture as to how, give a monetary value. But if you looked at case law, you'll see examples where that will be defined.
In your capacity, you're telling me that there is an earning capacity for those two persons. I'm asking you what that is. In view of the fact that you're telling me there is an earning capacity, I'm asking you to tell me what is that earning capacity. Because in the one instance, the housewife has been reduced to essentially a public charge. Her children are denied the advantages of a healthy mother. The husband is denied the wife's consortium. And in the case of the child becomes essentially a drain upon the society and becomes a public charge, or becomes a charge upon two desperate parents who now have an infant who is incapable of any support. And what I'm trying to figure out is, where is the justice of this speculative compensation that you're telling they might have in the way of economic damages? And how are we to be assured in any peculiar fashion that they are going to have the earning capacity, either the wife or the child, to support themselves? And how would the parents be having that kind of hope that some sort of blessing would be descending upon them from the Almighty, so that that child would not become a public charge in the event that something bad happened to the two of them?
Gentlemen, you.
I think we've got some splendid speculation, and I want to thank counsel for it.
Would the gentleman yield to me?
I'd be happy to, but I don't have any time. It's gone.
Well,
I ask unanimous consent the gentleman from Michigan be given 1 additional minute so we can yield, and we can then move on to the amendments.
okay, 1 additional minute. Gentleman from Georgia, would you like to?
And I'll be
respond?
glad to yield to the gentleman from Georgia.
Yeah, I thank my friend for yielding. I thank for the unanimous consent for additional minute to respond to the question of counsel. I think the counsel it was pretty clear in his response in regard to these two hypothetical cases that the distinguished gentleman, emeritus, former chairman, asked and presented in regard to the housewife.
Well,
in court, the plaintiff's attorney will probably testify to the fact that the housewife told her family members and her husband that she planned to, now that she's done her wifely duties, to go to law school and become a plaintiff's attorney and represent cases in med-mal. Or the child that's 4 years old, their parents were convinced.
Reclaiming my time, and I say this with great respect for my good friend, this is the most conjectural and doubtful kind of expectation. I don't have any reason to assume, and I say this with all respect to my friend from Georgia, to assume that there's going to be any jury that's going to say, or that there's going to be anybody, lawyer or doctor in this room, is going to be able to tell me what that amount might be and how we're going to see to it that a fair measure of justice is done to that housewife or that child.
Gentleman's time has expired. Gentleman from California is recognized.
I want to offer one of my 2 amendments now, and then I'll hold the last one for the
Gentleman
last
from California is
I have amendment number 2 dealing with intentional acts.
Clerk will report the title.
An amendment offered by Mr. Waxman of California.
Amendment will be considered as read, and the gentleman knows we have agreed to 15 minutes for both sides for both of these amendments, so gentleman is recognized for.
Well, I'll be very clear about this amendment, and I will ask for a roll call vote on it, because first of all, I want to commend Mr. Dingell, if he's still there, for bringing up the issue that he brought up, because a lot of these damages are quite conjectural. But I submit that H.R. 5 is extreme, and I want to give an example. I was stunned to find that the definition includes health care lawsuits, regardless of the theory of liability on which the claim is based. Usually we think of malpractice as negligence or breach of duty. But this language means that even if an individual commits intentional conduct which causes egregious injuries or death to patients, they are still protected under this law. The courts have said that intentional tort begins when known danger to the patient becomes a substantial certainty in the mind of the actor. Intentional torts include such claims as assault, sexual assault and rape, battery, false imprisonment, invasion of privacy, theft, misrepresentation, and fraud. This type of sweeping protection is unprecedented and goes well beyond the stated intent of the sponsors of the law of this bill. My amendment states that if it's an intentional tort, it not be included in the bill. I would hope that we could agree that H.R. 5 should not be used to protect the rare incidents of rape, assault, or even pedophilia and operating while under the influence. But let me give you an example. Dr. Ben D. Romilly, a Connecticut OBGYN, substituted his own sperm for that of a patient's husband during an artificial insemination procedure. The State Department of Public Health fined the doctor $10,000, and they allowed him to keep his unrestricted license. There was a lawsuit, was settled, but there's no record of how much this man ever had to pay, and that he was never faced with criminal charges. Now, my colleagues will say that's all okay because the bill does not apply to criminal liability, but that really is a fig leaf. Intentional tort is not the same thing as criminal liability. We have an appropriately higher standard for criminal liability, proof beyond a reasonable doubt. These cases have to be selected for prosecution, prosecuted in a court of law, and successfully convicted. Now, a lot of intentional torts are never prosecuted. The doctor I mentioned, Dr. Romilly, never faced criminal charges, so he would be protected under H.R. 5. It's worth noting that most incidents of sexual assault are never reported, much less investigated, much less prosecuted. And even if they are, criminal convictions take several years, and the statute of limitations would expire long before that process is completed. Well, these cases are rare, and we hope they are. I do want to point out, in one state alone, Georgia, CBS Atlanta reported multiple instances of drug abuse, rape, and child porn possessions. A urologist from Athens, Georgia, had his medical license suspended after being arrested and charged with raping a patient. An internal medicine physician voluntarily suspended his license after he was charged with sexual battery of 5 patients. And the Georgia Medical Board suspended the license of the emergency room doctor who was arrested for having child pornography. Now, this is rare, but there's no doubt that these kinds of things do occur. And because it is rare, removing this from the bill should not change the overall effect of this bill a great deal. I know that earlier this subject came up, and one of our colleagues said that intentional tort is a criminal matter, and therefore it should be prosecuted. Well, this bill is extreme. California does not say that intentional torts are covered with the liability caps. Texas doesn't do this. It makes no sense to protect individuals who intentionally put patients in danger. There should be no cap. It ought to be decided. It obviously, punitive damages are for punishment. To have $250,000 as the cap is an awfully low one if you've got somebody with a record of intentional actions and reckless disregard for other people. So I would think that we ought to take intentional torts out of the bill and let the bill apply to what we ordinarily think of as negligence and failure to live up to duty. And I'll yield back the balance of my time. Urge an aye vote.
Mr. Cassidy.
I think this bill is this amendment, no offense, is kind of beside the point. If we look on page 9, line 12, it speaks of malicious intent. Punitive damages are allowed if somebody executes, if you will, malicious intent. Looking on page 21, line 9, malicious intent to injure. The term malicious intent to injure means intentionally causing or attempting to cause physical injury other than providing healthcare goods and services. Healthcare goods and services is defined above that. It's a good or service that relates to the diagnosis, prevention, or treatment of any human disease, impairment, or the assessment of care of the health of a human being. Clearly, rape is not a healthcare good or service. So, aside from criminal charges, which appropriately should be filed to the fullest extent of the law, also punitive damages can be awarded. Similarly, if there is a malicious intent because you substitute something for something else, well, that frankly could be defined as an injury to the claimant, and so this would not apply. So, no offense, but it seems a little bit of a red herring to speak of something which is specifically excluded under this amendment.
Will the gentleman yield?
I will.
The point, you went through all of the points in this bill to illustrate that lawsuits can be filed for intentional torts. And a rape is an intentional tort. And if a lawsuit can be filed, I want to point out that under this bill, the damages are limited. Not only are the damages limited for the punitives, but they're limited as well for the non-economic damages. What is a non-economic damage? The pain and suffering of a woman that's been raped. Well, under this bill, it can't be more than $250,000. That's limited. The punitive damages are limited. Now, if it's an intentional tort, I would submit it ought not to be limited.
Well, if you have, obviously, once you are beyond the reach of this bill, I'm sorry, reclaiming my time, then you also have the potential for civil damages.
Well, that's what we're talking about, the civil damage.
But that said, the limits here are for 2 times the economic damages. If the economic damages are $1 billion, it theoretically could be $2 billion. So,
well, the gentleman yield further. The economic damages of a person who is the victim of a rape or an assault or something like that is limited to $250,000. The emotional damages are limited. So you may have twice the economic damages, but that's the limit on that part of the economic damages. And therefore, if you want to have punitive damages against a very bad person for behaving in a reckless way, that's limited even further.
There's 2 aspects to punitive damages. One, of course, is that which the victim receives, and the other, and theoretically, as some states, I think California has attempted, you can make an argument that those really could go to society as much as they go to the individual. But if we're speaking of punitive damages, then clearly being able to file criminal charges against a physician is punitive. And so,
but there are many cases where no criminal charges are ever brought.
But that is not the fault of the legislation. That would be the oversight by the attorney. I will yield to my
gentleman. Just a question with regard to this. If a medical practitioner is being charged with an issue of malpractice that relates to the practice of medicine, the examples my friend from California bringing out where someone may actually assault a patient is not in the practice of medicine. That person could sue and seek other civil damages in a case of a crime, as is typically happening, which has no limits on this bill as I understand it at all. It's an entirely separate issue.
No, if the gentleman would yield to me, that's the point I'm making. If they sue for civil damages, even for something that might be considered a crime, and they're not prosecuted, the civil damages are limited under this bill. So if you sue for civil damages from an assault or a rape or putting somebody else's sperm in, it's limited.
That's civil damage.
Gentleman has it.
As I discussed that with counsel, they said, listen, one, you have criminal charges, which again, it's not the fault of the bill if someone elects not to prosecute. Secondly, that there are the things that this bill applies to. But thirdly, if you talk about rape, that is not covered under this bill, and so that is a separate sort of civil
The gentleman would
charges.
submit, let's ask the counsel for a clarification. As I understand it, it would be covered by this bill. It's an intentional tort, and what I seek to do is to exclude intentional torts. But as I understand the bill, there are limits on the punitive damages as well as the economic damages if there's a lawsuit for an intentional tort under this proposal.
The bill applies to health care, good, or services, and as defined in the bill on page 21, they relate to the diagnosis, prevention, or treatment of any human disease or impairment, or the assessment or care of the health of human beings. Under the hypotheticals that you've drawn, rape would not qualify under that definition.
What would qualify as an intentional act under this bill?
As an intentional act?
Yeah.
So it would be, it's an intentional act that falls underneath a healthcare service.
Well, the proposal that I have is any intentional act that would apply to any civil suit, including healthcare suits, that's based on a substantial certainty by the actor that this person's going to do harm to the individual. In effect, what you're saying is some of those would be civil suits that would not be affected by this bill, but that's not the way we read it. If you believe that you're reading it the same way that I'm intending it, then you ought to support this amendment because it would clarify that it's not going to be covered, an extra protection that it's not going to be covered under this legislation. I would submit that.
Since I haven't been gavelled down yet, I'll reply
yeah,
that,
your time. So otherwise.
That since it seems it's already the intent of the bill that those things not be covered, it seems redundant, duplicative to accept the amendment. But that said, I yield back.
I wonder if the
Chairman.
gentleman might withdraw the amendment. Maybe we can work together, perhaps, to clarify the intent before the bill goes to the floor.
I'm sorry, what did you say?
I wonder if the gentleman might want to withdraw the amendment. Perhaps we work together to...
Well, I raised an issue of a doctor who uses his own sperm. That would be covered by the bill. Isn't that right, counsel? That's a service. He's acting intentionally.
That's not a health care service under the definition of this act.
I can't believe that's the case. A woman goes to see a doctor. She and her husband hope to get pregnant. The husband contributes sperm, but the doctor thinks, well, he'll just put his sperm in instead. That's not a health care service. In other words, any intentional act like that is not a health care service. But that's not the way I would read this bill.
The limiting factor is just that, the health care good or service. That doesn't fit under the definition. That's the limiting factor.
Well, I disagree, and I think that's the reason we ought to have this proposal. I'd ask for an aye vote. I'd ask for a roll call vote. If we want to continue to discuss it, we can do it.
Move to strike the requisite number of words.
Well, we have a little bit of a time agreement that we've now exceeded. We've got votes on the House floor
We've got
soon,
some
so-
other amendments as well. You
So
can vote
let's-
against it if you want to.
We'll suspend the debate on this. We'll ask for a recorded vote at the right time, and we'll go to the next amendment. Is that okay?
It's going to be rolled.
Okay. We'll roll this vote. Mr. Towns is recognized to offer an amendment.
Thank you very much, Mr. Chairman. I have an amendment at the desk.
An amendment offered by Mr. Towns of New York.
The amendment will be considered as read, and the gentleman is recognized for 5 minutes in support of this amendment.
Thank you very much, Mr. Chairman. I strongly believe that medical malpractice reform must remain within the purview of the states. We simply cannot afford to take a one-size-fits-all approach. I agree with my colleagues that it is a worthy goal to reduce malpractice premiums for physicians. Ultimately, this would result in a lower health care cost for everyone, but I do not think we should do so at the expense of quality care for patients. So the first part of my amendment addresses a serious shortcoming of H.R. 5. The purposes of the bill under Section 2 provide many worthy goals for malpractice reform, availability of services, defensive medicine, the fairness of this system, and better sharing of information. However, there is no single goal listed on quality and no mention of medical errors. So the first part of my amendment simply adds to the goal that we should improve quality and reduce medical errors. To me, this seems like a common sense approach. Perhaps my colleagues on the other side of the aisle accidentally omitted this aspect. But it's also possible that we simply don't know how to achieve these goals today. That's why Section 10607 of the Affordable Care Act authorized $50 million for grants to states to fund pilot projects to test different models of medical malpractice reform. Funding for these projects has already begun, including one project to test health courts, an effort praised by some of our witnesses that were invited by the majority during the hearing on this topic. I firmly believe that we should not move forward without H.R. 5, move forward with H.R. 5 until we are certain that there are no other better options out there for the states to adopt. The second part of my amendment states that the effective date for this act does not occur until 6 months after the Secretary can certify that the following 3 events have occurred. The grants under Section 10607 are completed. The Secretary has provided a report to Congress on these grants, and that the Secretary has certified that the provisions of H.R. 5 can achieve the purposes of the bill better than the pilot programs. There is no one-size-fits-all approach to medical malpractice reform, and we need to recognize that. States need to have the opportunity to find a model that works for them so that we can ensure quality and affordable health care for everyone. I urge my colleagues to support my amendment, and I yield back the balance of my time.
Gentleman yields back. Gentleman from Louisiana, Mr. Scalise.
Thank you, Mr. Chairman. I rise in opposition to the amendment, and of course, the reason that we're bringing this legislation is to lower the cost of health care, to allow doctors to be able to do what they're so good at doing, and that's providing great health care to patients instead of running all of these tests that many doctors will tell you are completely unnecessary for the patient's health, but only designed to prevent frivolous lawsuits. And the examples are endless, unfortunately. And at least we now have legislation to address the problem. Why anybody would want to delay implementation, and in fact, if you look at the amendment, it says even if it's proven, if it's certified to save money, still you have to wait another 6 months to implement it. We should be implementing these reforms today. And we need to pass this bill out of the House, put pressure on the Senate to address this problem, and hopefully encourage the President to live up to some of the rhetoric that he's given where he indicates he wants to support medical liability reform. Well, here's an opportunity we're giving him with H.R. 5 to put his money where his mouth is and support proven reforms. But we surely don't want to delay these reforms another day. We've waited too long already. I know we've got the letter from the American Medical Association in support of H.R. 5, but if you look at one of the things that they point out in the AMA's letter in support of this bill, they refer to the Congressional Budget Office estimate that enacting H.R. 5 reforms would reduce the federal deficit by $54 billion. Why would we want to put off for another day an opportunity to reduce the federal deficit by $54 billion, let alone the $200 billion of savings that families will benefit from if this legislation is passed? $200 billion in reduced health care costs that families won't have to pay gives them money to go out and maybe afford to fill up their tank one more time with the skyrocketing gas prices. But in many cases, it's going to afford that family the ability to buy good quality health care that they currently don't have, that they surely won't get under Obamacare. So you've got the opportunity right here before us with H.R. 5 to truly save money for families across this country and address the skyrocketing cost of health care, and also stop doctors from having to be focused on running all of these unnecessary tests that our family members don't want to have to go through. They won't want to have to schedule more MRIs and more CAT scans that their doctor knows that they don't even need to do, but they've got to run them because they're afraid of a frivolous lawsuit. And every doctor will tell you that. That jacks up the cost of health care. It puts so many inconveniences on family members that have to go through those tests. But more importantly, it saves $200 billion for families across this country. And according to the CBO, as the AMA points out in support of our bill, reduces the deficit by $54 billion. Why we would want to delay that implementation for one day
Would gentlemen yield?
I'd be happy to yield.
You know, we bring witnesses in here to talk to us, experts, and if I recall, one of them said, that we should wait and to see if we get additional information. And so funding for these projects has already begun, including one project to test health courts, an effort praised by some of the witnesses that came. These are experts. You know, why do we bring them in here if we're not going to take the advice or listen to what they say? Why would we waste their time? So the point of the matter is that they're suggesting that we do that. So why wouldn't we?
Well, in reclaiming my time to answer the question, first of all, the Obama administration didn't even request funding in next year's budget for some of those tests that you're talking about. So I think they don't even believe that they would have any kind of impact on reducing the costs. This legislation we brought forward, this isn't me saying it, this is the American Medical Association saying it, it's the Congressional Budget Office saying that we would achieve $54 billion in deficit reduction. That doesn't count the cost, the lower cost of health care to families. We ought to be implementing those kind of reforms right now, today. This is something that should have been done years ago, but at least we're finally here in this Republican majority with this legislation that does address it in a way that's been scored officially to do some very positive things for families who have been looking for this kind of relief. So I don't believe we should delay it. I think experts that have looked at it clearly suggest that you would get these savings if you implemented these reforms without delay. So I would just urge rejection of the amendment and be happy to yield back the balance of my time.
Gentleman yields back. All time has expired. Those in favor of the Towns Amendment will say aye. Aye. Those opposed say no. No.
Mr. Chairman, I ask for a recorded vote.
Gentleman asked for a roll call vote, and it will be rolled with the earlier votes. Chair would recognize Mr. Markey for an amendment.
I thank the Chair. My amendment is at the desk.
Clerk will read the title.
An amendment by Mr. Markey of Massachusetts.
And the amendment will be considered as read, and the gentleman is recognized for 5 minutes in support of his amendment.
We have two values that are competing against each other here today. On the one hand, we have people who have been injured, they've been harmed, their families have been harmed, and our hearts go out to them. On the other hand, we're saying that doctors have to pay premiums that are skyrocketing, and we have to do something about it. So we're faced with this tension that exists because we care about both things. And so what the majority has decided is that there should be a $250,000 limit on non-economic damages for someone who has been injured. So let's take a case. Let's just say that there's a 17-year-old. They've been in an operation in a hospital. The physician has made a mistake. And because they have injured the spine of the 17-year-old, that 17-year-old is going to be a quadriplegic for the rest of her life. And so they go to the jury. The jury sees this quadriplegic 17-year-old girl. They understand the totality of all the consequences for her. And they render a $5 million non-economic damage verdict. But once this law goes into effect, all she can get is $250,000. Now, what the other competing interest is, we want to keep insurance premiums lower. And so what my amendment says is that the jury's not be instructed that there's a $250,000 limit. They're not told what the limit is. So the juries can return whatever verdict they want in terms of monetary compensation. Then what my amendment says is that there'll be a trustee that will take the remaining $4,750,000 that otherwise would have gone to the girl, and that will be in a fund that will be administered by the trustee to ensure that the insurance premiums of the doctors who are insured by that firm go down, and that all of the all of the decisions that have granted an award greater than $250,000 all go into that fund. Then the insurance premiums will go down. Because as you look at the evidence across the whole country, there is no evidence that insurance premiums ever go down for doctors. That the insurance industry, and we trust the insurance industry, but maybe we should play it safe here. And that's what my amendment does. It just makes sure that all of the money, and we can actually know how much the insurance industry
saved. We'll know the amount because the juries will have told us how much it was. And then all that money is put in a fund for that insurance company by the trustees, and then they can say to that company, here's how low your rates have to go. Here's how much money you saved. Huh? Then we'll have physicians that can stay in their specialties. Then we'll have physicians that can stay in a community that otherwise they'd have to move out of. Because the evidence is that there is no difference between states that have already imposed caps and states that have not imposed caps. They have actually paid just about the same for premiums right now. So that means that even after the state has put a cap on, the insurance industry hasn't lowered the premiums to a point that's any lower than the states that don't. So that's where we can play a big role here. By imposing a $250,000 cap, but yet having this additional formula, then we'll be putting the pressure on the insurance industry to lower those premiums, where right now there is no such evidence that it occurs. So we don't want to cap what a victim, what this girl can collect, and then see the rates for doctors to be raised. That's a cap and raise. Huh? We want to cap and cut. And the only way we can cap and cut is if we know what it was. And we can find that out just by allowing the jury to return the verdict. And so that's what my amendment does. It's just quite simple. And then while the girl might be, unhappy that she's only able to receive $250,000 for the rest of her life and living another 60 or 70 years, at least we'll know in good conscience that we did something for the doctors, because we will have that trustee to make sure the insurance industry then lowers the premiums and the doctors will be the beneficiaries. So that's my amendment. I urge its adoption. I think it dovetails perfectly with what the objections of the majority are in trying to help the physicians and not the insurance industry in our country. So I yield back the balance of my time.
Gentleman from Georgia.
Mr. Chairman, I respectfully oppose the Markey amendment. The gentleman from Massachusetts is obviously a very intelligent, cerebral member, and put a lot of thought into this amendment, I'm sure. But quite honestly, we have, as we've said earlier, in response also to the Towns amendment, we have had 35-year pilot projects in the case of California, and indeed Ms. Baldwin's case in regard to what she described that has been done way back in 1975 in Wisconsin. These pilot projects are the proof of the pudding. My statistics may not be exact, but over a 10-year period or so since the passage of MICRA in California, the increase in the aggregate of the medical malpractice premiums is in the neighborhood of 150% over X number of years. And in states that don't have caps, it's 800%. So the proof of the pudding is in the eating. Clearly, the Markey Amendment is trying to fix something in that regard that's not broken. That's why it's so important in H.R. 5, the provision in regard to the caps. The other thing that I want to point out to my colleagues is that in this country, probably 65%, if not more, certainly more in Texas, of practicing physicians are insured by mutual companies, like the Medical Association of Georgia Mutual Insurance Company, MAG Mutual, the Texas Medical Liability Trust, whereby any savings, any reduction allows these companies to lower the premium. And that's, the doctors don't need to rely on some court-appointed trustee to do that. It's already happening. So, again, I know the gentleman is a senior, well-respected, intelligent. I know he thought out this amendment, but I just think that we don't need that, that the provisions of H.R. 5 worked better. And the proof of the pudding is in the MICRA law.
Would the gentleman yield?
I'll be glad to yield to my friend.
Just so you know, the Mass Medical Association, the physicians in Massachusetts, the society has endorsed my amendment. I mean, this is where physicians, at least in my state, believe they can be sure that they get the lower premiums. And so, you know, I just want people to know that this is meant to really to side with the doctors on this against the insurance industry to make sure they get.
Well, I thank the gentleman for those comments. And in reclaiming my time, again, I respectfully oppose the Markey amendment. I yield back.
Will the
my
gentleman
time.
yield?
I'm sorry, I've already yielded back. Otherwise, I would, but I
Gentleman's
yield back.
time has expired. All time has expired. Those in support of the Markey amendment say aye.
Aye.
Those opposed say no. No. Noes appear to have it. The noes have it. Roll call vote is asked for. We will bring up the call up the remaining amendment.
Let's just do it when we get back.
Okay. Votes have been called, so we have one remaining amendment with a time agreement, 5 minutes aside. So we will complete these votes. Do you want to try to come back at 6:20?
If we can do it.
We'll come back immediately, see if we can't debate the last amendment and start the roll call votes to finish the vote. So we have three votes in the queue. We have the Waxman vote to debate, a time agreement, 5 and 5 on the side, and final passage. We'll see if we can't get started at 6:20.
So the MOE will start tomorrow.
And then you have the opening statements, which are going to happen tomorrow.
That's right.
So,
Yep. MOE openings will start tomorrow.
Right, so that will start tomorrow, which means everything gets delayed.
Right.
Opening took how long here yesterday? About an hour or two?
About an hour.
Yeah, so I figured that's going to start late tomorrow. I mean, later.
It won't start, yeah.
It won't get to